Welcome to our 2010 Voting Rights Symposium, a national dialogue on the state of voting rights in 2010, past, present, and future. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. And for those of you who are not familiar with ACS, we're a national network of lawyers and academics, policymakers, and law students that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. 1 week after Bloody Sunday in 1965, when 600 civil rights marchers were attacked by state and local police with billy clubs and tear gas in Selma, Alabama, while they were preparing to march to Montgomery to protest voting rights discrimination, President Johnson declared that every American citizen must have an equal right to vote. There is no reason which can excuse the denial of that right. There is no duty which weighs more heavily on us than the duty we have to ensure that right. And there is no doubt that significant progress has been made since that date to ensure the right to vote for every American. But as we all recognize, challenges do remain. Today, we have a simply outstanding program that will examine the state of voting rights in 2010. And the timing for today's program could not be more propitious, as it coincides with the recent 45th anniversary of the Voting Rights Act, the 2010 midterm elections in November, and the impending cycle of redistricting based on the 2010 census figures. We are pleased to bring you three very extraordinary discussions today. The 45th anniversary of the Voting Rights Act gives us an opportunity not only to celebrate the Act's monumental achievements, but also to examine its present and future effects. The first panel will examine the Voting Rights Act in the wake of the two recent Supreme Court cases, Bartlett versus Strickland and the Northwest Austin Municipal Utility District No. 1, known as NAMUDNO. Panelists will discuss recent developments and legal challenges surrounding the Voting Rights Act that may have an effect on future elections and the upcoming redistricting cycle. This panel will be moderated by Gilda Daniels, an associate professor at the University of Baltimore School of Law and former deputy chief in the Department of Justice Civil Rights Division Voting Rights Section. She will facilitate a discussion with 5 very distinguished panelists, all of whom have an extensive knowledge of or experience with the Voting Rights Act and the field of election law. The full biographies for all of today's speakers, this panel and the one following the lunch, are included in the handout you received at the registration table and will be introduced briefly by the panel moderators. Following this panel, we are honored to welcome Congressman John Lewis, a civil rights legend and currently a United States Congressman, and Taylor Branch, a Pulitzer Prize-winning historian known for his extraordinary work chronicling the civil rights movement and the life of Martin Luther King. These two gentlemen will participate in a lunch conversation entitled The Road to Democracy, which will provide historical reflections on the struggle for voting rights and examine thoughts about where we stand on voting rights today. And finally, after lunch, we will conclude the symposium with a panel on possible issues and challenges presented by the 2010 midterm elections. This panel will be moderated by Anna Henderson, the Director of Opportunity and Inclusion at the Chief Justice Earl Warren Institute on Race, Ethnicity, and Diversity, and will feature 5 outstanding scholars and practitioners in the field of election law. Panelists will discuss a wide range of topics, including voter registration, accessibility issues for limited English proficient voters, the role that partisanship plays in litigation and in election reform, National Voter Registration Act enforcement and compliance, and issues surrounding provisional ballots. We clearly have put together a very full day for all of you, and I'm sure it's going to be extremely stimulating and informative for all of us. So to get us started this morning, please join me in welcoming Professor Gilda Daniels.
Thank you, Caroline, and thank you to the American Constitution Society for putting on this wonderful event today. It certainly is timely in that we do have the 2010 midterm elections as well as the 2011 cycle, 2011 redistricting cycle coming up. I am Gilda Daniels. I'm an assistant professor at the University of Baltimore School of Law and a former deputy chief at the Department of Justice Civil Rights Division voting section, and I'm honored to participate today on this panel with this esteemed panel of experts. Now, the 2011 redistricting will provide some interesting challenges for minority voting rights. How can we preserve minority electoral opportunities and gains in the wake of Bartlett v. Strickland? And how will the Department of Justice address changes in Section 5 procedures pursuant to NAMUDNO and the Georgia v. Ashcroft fix in the 2006 reauthorization of the Voting Rights Act? What is the impact on future voting rights litigation, and are coalition district claims viable as an opportunity to continue the electoral gains made since the passage of the Voting Rights Act? Are majority-minority districts safe from legislative backsliding? This panel will discuss these and other issues today and hopefully provide a roadmap for voting rights advocates as we prepare for the next redistricting cycle. And we have an esteemed panel today that includes Kristen Clark, who is the co-director of Political Participation Group at the National Association of Colored People, NAACP-LDF, the Legal Defense Fund. She oversees and coordinates the activities of LDF's legal program in the areas of voting rights and election law. In 2009, LDF successfully defended the Voting Rights Act against a constitutional challenge in the NAMUDNO case. She was formerly a staff attorney at DOJ in the voting rights section as well as the criminal section. She writes frequently on issues concerning race, law, and democracy, and her latest book is Barack Obama and African American Empowerment, The Rise of Black America's Leadership, which she co-edited with Dr. Manning Marable. Next we'll have Robert Kingle, Bob Kingle, who is the co-director of the Voting Rights Project at the Lawyers Committee for Civil Rights Under Law. He's a former special counsel and a deputy chief in the Department of Justice Civil Rights Division voting section, and one of my colleagues that I worked with while I was at the DOJ. And he's litigated cases under Section 5, Section 2, a myriad of voting rights litigation. He also serves as an adjunct professor at Georgetown University Law Center. Then we'll have Keith Gaddy, who's a professor of political science at the University of Oklahoma. He is the editor of the Social Science Quarterly. He is a litigation consultant in voting rights and redistricting cases for both parties, both Republicans and Democrats, and he's also testified before the House and Senate. We also have Anita Earls, who's the executive director for the Southern Coalition for Social Justice. She's a co-founder of the Southern Coalition for Social Justice, which is a nonprofit organization in Durham, North Carolina. She's been a civil rights attorney for more than 20 years. She specializes in large impact voting rights and structural racism and community empowerment issues. She also served as a Deputy Assistant Attorney General in the DOJ Civil Rights Division. And finally today we'll hear from Nina Perales, who is the Southwest Regional Counsel for MALDEF. She directs MALDEF's litigation, advocacy, and public education throughout the Southwest. She specializes in vote dilution and redistricting cases, and she successfully argued LULAC versus Perry in the United States Supreme Court. Our panel today will consist of 3 separate sections. First, we'll have introductory remarks from each of the panelists, and then we will have a panel, I will facilitate a panel discussion, a discussion amongst the panelists about various voting rights issues, and then you will have an opportunity to ask questions of our esteemed panel. Kristen, if you go ahead.
Great. Thank you for that warm welcome, Gilda, and thank you to ACS and LaShawn Warren for organizing this very important and timely event. It's a real honor to be up here with this very distinguished panel and in the company of so many folks who are involved in the day-to-day work of enforcing our Voting Rights Act. So I thank you. What I wanted to do to start off this morning was to talk about this very important moment. We do indeed stand on the eve of the upcoming redistricting cycle. And this is indeed one of the most important events in American democracy. We elect our nation's president every 4 years, senators every several years, but redistricting generally happens only once every decade. As you all know, the release of the 2010 census data, which will come at the start of next year, will unleash redistricting at the local, city, county, state, and federal level all throughout our country. And it is so very important that we be engaged and encourage others to be engaged in this very significant process. But it is also equally important that we ensure enforcement and compliance with the Voting Rights Act during redistricting. So what I wanted to do was talk a little bit about the context in which we approach redistricting next year. One, I think it is very important to note, as it has already been stated, that this is indeed the 45th anniversary of the Voting Rights Act, and it's important to reflect on the great progress that we have made during the 45 years that we've had the protections of the Voting Rights Act in place. But we need not be blinded by that progress. We know that the reality is one in which ongoing discrimination remains a significant problem throughout our nation. In 2006, Congress reauthorized the Section 5 preclearance provision of the Voting Rights Act, widely regarded as the heart of the Voting Rights Act. They conducted extensive hearings, heard from numerous witnesses, compiled a congressional record that was more than 20,000 pages long, and at the conclusion of that process, determined that Section 5's protections remain necessary. And throughout the life of the Voting Rights Act, we have found that Section 5 plays its most important role during the time of redistricting. It's where we see the Justice Department and the DC District Court blocking discriminatory voting changes, discriminatory redistricting plans that hurt, harm, and dilute minority voting strength. So Section 5's protections remain absolutely vital during redistricting, and Congress concluded by a vote of 98-0 in the Senate that Section 5's protections remain necessary and renewed and reauthorized Section 5 for 25 years. But it's also important, I think, to be mindful of the fact that Section 5 is under attack. There was a case filed in 2006 that many of you are probably familiar with, NAMUDNO versus Holder. It was signed days after former President Bush signed the Section 5 renewal bill into law. That case made its way all the way up to the Supreme Court, and last term the Supreme Court rejected the challenge, resolved the case on statutory grounds, and left Section 5's protections in place. That's a good thing. But in the last several months, there have been a number of cases filed that again take aim at Section 5 of the Act. One of those cases was filed by the state of Georgia, Georgia versus Holder, and it looks at that like that case is dying a very quick death. Another case arises out of North Carolina, a case that my counterpart Anita Earls is involved with. And there is a third case filed by Shelby County, Alabama versus Holder. The litigants in many of these cases have made clear that their goal is to indeed disrupt Section 5's protections during redistricting and are seeking to litigate these cases on a fast track. The civil rights community is very much aligned in support of Section 5 and aligned with Congress's view that Section 5's protections remain necessary. And we need to ensure that in those jurisdictions, those 16 states where Section 5 applies, that there is a complete compliance with its mandate during redistricting, that redistricting plans are drawn in ways that fairly reflect minority voting strength throughout our country. So those, I think, are two very important points to note as we go into the next round of redistricting. But you know, I also want to note the kind of role, significance of the 2008 presidential election. There are some who have, I think, prematurely begun to describe this era as a post-racial one. We've elected our nation's first African-American president, thus we must clearly have overcome the problem of race. And I think that those commentators are wrong. When you conduct a close analysis of the election itself, you see that racially polarized voting remains a part of our political reality in this country. Indeed, in many of the jurisdictions where Section 5's protections apply, Louisiana, Mississippi, Alabama, and other covered jurisdictions, it's in those places where we saw the highest levels of racially polarized voting during the 2008 election cycle. And indeed, I think these are very tense times. So we need to ensure that the 2008 presidential election is not used as a pretext to unravel the very fragile gains that have been made with respect to minority voting rights over the last several years. Finally, there are other cases that have come down from the court that others will talk about later that may indeed impact the way redistricting is carried out. Bartlett versus Strickland is one of them. And I just want to note something from Justice Kennedy. Justice Kennedy's observation and the opinion that was issued in the Bartlett versus Strickland case that I know will be talked about more later. There, Justice Kennedy observed that racially polarized voting and ongoing voting discrimination remains a part of our political reality. And I think that that's a very astute observation from Justice Kennedy, a very recent observation, and one that really needs to shape the context as we go into this next redistricting cycle. Discrimination remains a part of our political reality. And we need to ensure that we work to see a redistricting process in which plans are drawn that reflect the growing diversity of our nation, ensure that we fight back against some of the ills that we've seen during past redistricting cycles, packing, for example, where minority voters are unnecessarily packed into districts, diluting their ability to exercise influence in other places, cracking, where politically cohesive groups of minority voters are unnecessarily fractured, and ensure that in those areas that have experienced significant minority population growth, that the line drawers are working to draw and create new districts in those areas, be they majority-minority districts, influence districts, or coalition districts. So I'll conclude here, but I think, you know, it is also so very important that we create an incentive to comply with the Voting Rights Act. The Voting Rights Act throughout the years, voting rights litigation throughout the years has proven extremely costly, time-consuming, and burdensome. And I think that this should provide an incentive for us to figure out what role the Voting Rights Act plays and ensure that line drawers comply with the Voting Rights Act's mandate during this upcoming redistricting cycle. Thank you.
Thank you. Bob?
Good morning. Like Kristen, I very much appreciate the opportunity to appear here this morning and to address everybody. I apologize in advance. I'm not sure how long my voice is going to hold out here this morning. I seem to be in the process of losing it. So my remarks may be briefer than brief. But what I had hoped, at least, to be able to cover with you in my opening remarks here is to give you some sense of what it is that the voting section at DOJ is facing now. Obviously, I'm not here to speak for them anymore. I left DOJ in 2005, so it's been now about 5 years since I was there. But I think I do have some sense of what it's like and what is on their plate. The voting section, it seems like it has been buffeted for about the past 17 years, to me at least, going back to the decision in Shaw versus Reno, and then the subsequent cases built on that. It really sort of took away the voting section's focus from what had been the traditional focus on Section 2 enforcement as well as Section 5. And a lot of resources and time were spent on that Shaw litigation during the 1990s. Then once that pretty much wound up, we moved into the Bush administration, and a lot has been said and written about those years that also, I think, in my view, took away from the section's traditional and proper focus. Now, in the Obama administration, if you read the headlines, you see that the voting section is once again in the news with regard to the new Black Panther Party investigation, and that is taking some of the section's focus as well. But at the same time, the section is still moving forward. The section is still getting things done. From our perspective, we had hoped actually to see some more in this administration under Section 2 of the Voting Rights Act and under Section 7 of the National Voter Registration Act. But the department has pressed forward. It is defending the constitutional claims against Section 5 of the Act that Kristen referred to, and there have been a series of Section 5 objections, and the section has been active under UOCAVA as well. That's the Uniform Overseas Citizen Absentee Voting Act. I think that's the title. but there's a focus on the upcoming redistricting, and so the section department are doing several things. One is that they are ramping up hiring. There had been some change in the hiring focus during the Bush administration that led to a downsizing in the staff devoted to Section 5 submissions. I think that is that's being turned around, and that staff is now being built up and trained. Attorneys in management positions have been advertised, and I believe they're in the process of being filled now. So this is geared toward having the staff ready to deal with the deluge of redistricting plans that will begin coming in. There are proposed amendments to the Section 5 guidelines that have been published, and there's been a comment period on that. The Lawyers Committee has submitted some comments on those. The section is also following up on bailouts that are a consequence of the MUD decision, the NAMUDNO case. Just the other day, 2 bailouts were granted, and earlier the MUD itself, that was the plaintiff in the NAMUDNO case, bailed out. That was in September of last year. So the department has publicized the availability of the bailout procedure, and I think it remains to be seen how many jurisdictions want to step forward. Certainly, as a result of the NAMUDNO decision, there are many more jurisdictions that are eligible to seek bailout. Before the NAMUDNO decision, it was limited to political subdivisions in states, whereas now any governmental unit that's covered under Section 5 is eligible to seek bailout. I'm probably running short on time. 2 minutes. I guess one of the things that I should mention is that during the 2006 reauthorization, Congress addressed the decision in the Georgia versus Ashcroft case. I think you've heard a reference to that previously. For those of you who are not familiar with it, this was a declaratory judgment action by the state of Georgia that sought preclearance for 3 redistricting plans, a congressional, state Senate, and state House plan. DOJ opposed preclearance for the state Senate plan. The district court ruled in DOJ's favor. On appeal, the Supreme Court found that the district court had not properly considered whether influence districts fit into the equation. It had looked at districts where African American voters were able to elect candidates of their choice, but had not considered influence districts where African American voters wouldn't be able to elect candidates of their choice, but at least arguably could influence the outcome of the election in some way. So the case was, the decision was vacated and remanded to the district court. It was dismissed before it went on to further decisions. But in looking at that decision, Congress amended the language of Section 5 to clarify that the focus of Section 5 is on the ability to elect preferred candidates of choice, was the language that was used. And so that took away from the influence district calculation that the Supreme Court had interpreted Section 5 to contain. That really hasn't been addressed in any litigation so far, but I think that was the intent of Congress. One thing that I would want to clarify about that is that in using the term influence district, you're not necessarily talking about any district that would be below 50% in terms of the minority voting age population or effective voter population. The court identified what were called coalition districts or opportunity districts. There are districts where there is some white crossover and you're able to elect a minority candidate of choice. Is not necessarily a district that's over 50%. That's cognizable under Section 5. I see my time has run out.
Thank you.
Thank you.
Bob, I'll see if I can make up the slack here real quick. First of all, my thanks to the ACS for the opportunity to be here and to be on this distinguished panel. It is excellent company. I'm not a lawyer. I come here as a political scientist who has an interest in the Voting Rights Act from a historical perspective and from an intellectual perspective, and as someone who has an interest in electoral systems from an intellectual perspective and as a mechanism to ensure access and efficiency in translating the public's preferences into government. To that extent, I'm going to speak a little of bad news and a little of good news as I see it, which is that when I look at the NAMUDNO decision and the environment we're in right now, NAMUDNO is a warning signal from the Supreme Court, which is a laggard court. It is a court that doesn't represent any majority in the current political environment. It represents a past ideological political majority. But it still has tremendous constitutional authority over Section 5. And when I look at the NAMUDNO decision, I see in that decision and in Clarence Thomas's partial dissent a rough draft of a decision that would have overturned Section 5. And when I look at the cases that are coming down the pike, Shelby County in particular, I see a challenge coming back at the Supreme Court and a situation where we could see Section 5 overturned, or we could see Section 4 overturned. Now, this is not the only signal coming from this court. This court has made similar signals in campaign finance, in the Citizens United case, which is one of a series of signals regarding campaign financing in the United States. It has made signals on aspects of the rights of the accused. Since the mid-1990s, we had a series of conservative signals out of the court of the direction they were going in, and we had these on voting rights as well. There is nothing new in Justice Thomas's dissent that he has not been saying since the 1990s. There's a shame in this situation, which is that Congress was presented with an opportunity in 2005 and 2006 to look at these potential remedies and to address these potential defects and to address them in law. And Rick Pildes sat next to me in front of the U.S. Senate and made a very strong argument for revisiting the design of the trigger, for revisiting bailout in order to keep Section 5 viable. My recent book with Chuck Bullock, Triumph of Voting Rights in the South, documents tremendous gains in voting rights across the South. But those gains are variable. There are parts of the South that are still in desperate need of Section 5. They need even more Section 5 than they're getting, more than likely. But there are also parts of the country where Section 5 does not apply, where it could be very useful, where we have lagging voter participation, where we have historic discrimination, where some or many of the Senate factors can be met. The one thing that's missing is the historic use of a test or device that is component to the old Section 4 trigger. Many of these communities have large Native American populations, Hispanic populations, poor populations. But the law at present does not allow us to examine changes in their voting systems and ascertain if discrimination is going on. That opportunity was missed. Now, the reason I bring this up is that if Section 5 is overturned by the court, it couldn't come at a worse time. Forgive me if I seem like Cassandra here, but there is a nationally divisive politics at work. You all live in it every day. We see it out in the heartland, also out there on the plains, where states' rights has been re-legitimated as a political philosophy, as a theory of government in the United States. There's talk of re-examining the scope and application of the 14th Amendment with regard to citizenship. This quiet rehabilitation of the rhetoric of states' rights challenges the authority of the national government to take emergency action where needed. And it takes advantage in part of some deemed magical authority that exists under the 10th Amendment and largely seeks to intellectually ignore the Reconstruction amendments that are so important to voting rights. I'm very scared and worried over the challenges that are coming, in part because steps could have been taken to preempt them. There are things that could have been done in legislation, in creatively developing a new Voting Rights Act that preserved the gains of the past and also set us up to deal with the challenges of the future. And I don't think that can happen in the coming Congress. I don't think the will be there or the willingness. If anything, we may end up with a majority that wants to go in a very different direction. Okay, so there's the bad news. Forgive me for the wet blanket. Here comes the good news. The good news is that there are creative things that can be done with electoral systems that are now being done that can achieve minority access to the electoral process and help get past the Bartlett problem, which is that we look at alternative voting systems. We look at multi-member districts with the use of cumulative voting systems to elect lawmakers, to elect commissions, to elect councils. And we assure that in designing those, they will meet a standard of performance where representatives of choice or candidates of choice can be elected. Actually, Peyton, it's funny, the last time I saw you was up in Port Chester. Little case village of USC Village of Port Chester, a little village of 25,000 people is challenged under Section 2 by the U.S. Attorney. This 2-square-mile village is presented with a remedy of 6 single-member districts in a 2-square-mile area. But the demographers disagree over the ability of the district to meet a majority-minority in the electorate. So the judge takes up the village on their offer to put a cumulative voting system in, along with voter education, bilingual ballot information, which Westchester County was already under a memorandum of agreement, I believe, to provide these materials in any event. That system goes into force. It elects the first Latino representative to the village council. It also elects our African-American representative, which brings more diversity onto the 6-person council than had ever existed in the past. It is permissible in state legislatures, it is permissible in city governments, it is permissible in county governments, school districts to use these remedies. They can perform, they can work. And the principal advantage they have is, in the village of Port Chester, it allowed the vast majority of Latino voters in Port Chester who lived outside the proposed single-member district to vote and elect a representative of choice. So alternatives exist, and they are being tried. And my hope is that we can seriously consider advancing these kind of remedies, either affirmatively or as solutions in litigation where they can apply. Thank you.
Anita?
Good morning. I also want to thank the ACS. I want to assure you that we are continuing the establishment of a chapter in North Carolina, and we really appreciate all the work that you're doing throughout the country. It's also really gratifying to me to see so many friends and colleagues in the audience, including one of my former students at UNC Law School, so that's very gratifying. In light of what's been said already, I'm going to just focus on a couple of things. I want to say a little bit more about the implications of the Bartlett case for the next round of redistricting, and then give you a picture of what I see going on primarily, my view is from the South, but I think more broadly in the areas of the country where minority representation is a crucial issue. What's going on right now to prepare for the next round of redistricting, and then talk a little bit about some positive steps that I think, including some research that could be done, but some positive steps that can be taken. So the implications of Bartlett. I think it's important to remember that the Supreme Court said that if a jurisdiction wants to draw a district that empowers minority voters but is less than 50% minority, they can still do that. The question in the case was whether or not Section 2 of the Voting Rights Act would require a jurisdiction to draw such a district, and the court said, no, you have to, the plaintiffs in such a case have to demonstrate that a majority, a 50% voting age population district is possible in order to establish liability under Section 2. So going forward, one potential implication is that districts that currently elect candidates of choice of black voters but are less than 50% voting age population and are not protected by Section 5 of the Voting Rights Act could be at risk. That legislatures and other bodies drawing maps don't necessarily have to, under fear of Section 2, liability under Section 2, have to draw those districts. We took a quick look at using the 2006-2008 American Community Survey data, looked at the districts that currently elect the members of the Congressional Black Caucus. 15 of those districts are less than 50% in total population. We don't have the voting age data. But only 8 of them are not covered by Section 5. So you can begin to see the crucial role that Section 5 will play in the upcoming round in sort of filling in, because that requirement of being able to show a 50% voting age population district is not true under Section 5. Section 5 has a very different standard in that regard. So while we are concerned about districts that may not be protected, we remember that the court did not say you can't draw those districts, just that they're not required by Section 2. And so there's a lot of advocacy that can go on the ground trying to convince legislatures to be fair to minorities in their jurisdiction. So what's happening, what I see happening is a lot of community-based organizations getting informed about redistricting, sort of following on the big push to get everyone counted in the census. Some of those same nonprofits are now involved in learning the redistricting process, getting access to the technology so that they can effectively draw plans. My organization, the Southern Coalition for Social Justice, we trained in July 18 demographers and 12 social scientists to draw maps and to do the racially polarized voting studies, and brought them together with community organizations so that in the redistricting process, as the maps are being drawn, that information can be put into the record. They can really have an effective voice and a role in the redistricting process. So I think that's a very important way to make sure that at the front end, we're drawing plans that are fair to minority voters. In terms of what we can be looking at now, and I mentioned the research question, I think it's very important to look at what litigation has been successful in the past in challenging redistricting plans. When you talk to the people in state legislatures who have to actually draw these plans, the general sense is we're going to be sued no matter what we do. And you can look at the number of states who were sued after the last round of redistricting, and yeah, the data kind of supports they're going to be sued. But I think a more important question is what kind of challenges will be brought, and what challenges are successful in actually blocking or changing redistricting plans. And I was just at the National Conference of State Legislatures meeting in Providence where Kristen spoke, and one of the questions that came from the audience was, well, why have there not been any successful SHA challenges in the past 10 years? And I think that's an important question, because it's true that there haven't been as many successful SHA challenges. And interestingly, one of the panelists said, well, that's because we all know, this was Dale Oldham, who's worked with on redistricting for the Republican Party, and I was stunned as someone who had litigated the SHA cases. He said, we all know that the funny shape of the districts never had anything to do with protecting minority voters. It was to ensure Democrats getting elected. And so once the court ultimately said, if you can demonstrate that the shape of the district is due to partisanship, not to race, that's really a defense to SHA claims, that kind of quieted the litigation on the SHA front. But I think that's an important question. What legal theories, what challenges are likely to be successful? That's what we should be paying attention to as we go into the next round of redistricting. And the final thing I'll say is that there's been some I think, very significant and important research done recently coming out of the state of Florida about the impact of compactness. And when you have compactness as a criteria for drawing districts, what does that mean? What they found was that it clearly means that there's a partisan bias and that you end up drawing disproportionately more Republican districts than Democratic districts. And to the extent that that then has an implication for minority voters, that's important. And part of the reason for that is because the urban Democrats and minority voters are more concentrated, residentially concentrated in urban areas, whereas in the rural areas you actually have more of a mix of both Democratic and Republican voters. So in Florida they found they drew over 200 plans and they still couldn't get one that didn't favor Republicans using the data from the 2000 election as their measure of who's Republican and who's Democrat. So I think understanding the impact of these supposedly neutral sounding redistricting criteria that actually have a partisan bias and then have implications for minority representation is an important thing going forward.
Thank you. Nina?
Thank you. Thank you very much. Whoa, I can't use the court voice. Thank you very much to ACS and to LaShawn Williams and the ACS leadership and staff for having me here. It is always a huge honor and a huge presence to be here and to see so many folks I don't get a chance to see because you never come to San Antonio. So think about it. It's beautiful, the Riverwalk. It's a lovely place. I'm going to talk a little bit about the Latino perspective on the upcoming redistricting round and hopefully weave it in a little bit with what's been said so far. I have to start with a frame for looking at redistricting from a Latino perspective, and that's demographic growth. I want to share with you a few key facts about Latino demographic growth so that we're all on the same page here. It's important not just to see who is eligible now to vote within the Latino population, who now is over the age of 18 and is a United States citizen, but also what's coming. And I think folks on the conservative side are very, very conscious about what's coming, and this is driving a lot of what's going on right now in the area of Latinos and voting. So right now there are an estimated 48 million Latinos in the United States. That's about 15.8%, 16% of the population nationwide. But obviously in other areas it can be much higher. So the latest estimate of Latino population in Texas, where we have of course always been a minority, is that Latinos are now 37% of the population in Texas. It's a very big number. And I'm very proud to say that my daughter's cohort in school, she is a first grader, is the first cohort or the first group of children moving through the public school system that is majority Latino. So since she's 6, you can see that in 12 years, the graduating high school, not 12, what am I saying? Yes. In 12 years, because he's in the first grade. I'm like, this is my numbers guy. That's right. In 12 years, he can add way better than I can. 12 years, then the graduating high school seniors in Texas will be majority Latino, right? That's a really big deal. Most Latinos were born in the United States, despite all of the anti-immigrant rhetoric and everything you're hearing if you flip around on the TV stations. Most Latinos are born in the United States. Most Latinos are United States citizens. About 73% of all Latinos in the United States are U.S. citizens. And then the remaining proportion, of course, is a mix of people who are here with permission, legal permanent residents, and other authorized immigrants, and then, of course, a smaller group of unauthorized immigrants. It's hard to find statistics on the children born, U.S.-born children, of Latino unauthorized immigrants, but I do have a number that encompasses the U.S.-born children of all unauthorized immigrants. That would include unauthorized immigrants from all nations, from Asia, from Latin America, from Europe, you know, the children of unauthorized Irish immigrants. And that number is that there's about 4 million U.S.-born children of unauthorized immigrants living in the U.S. And that's an important number because it's become kind of, I don't think it's that big a number, 4 million, but it's definitely become a point of focus lately. Now moving back to eligible voters, there's about 19.5 million Latinos who are eligible to vote, meaning U.S. citizens and over the age of 18. That's up from 16 million in 2004, so the numbers are growing pretty fast. Right around now, we're about 9.5% of citizens over the age of 18. One more thing to note is that there has been a sharp U-turn in the trend of Latinos to diversify their partisan affiliation. Latinos were trending towards voting in more diverse ways, voting for Republicans and Democrats. In 1999, there was about a 33-point percentage gap between those who were voting Democrat, the larger group, and those who were voting Republican. By 2006, the gap had narrowed to only 21 points. So it was a very fast shift towards diversifying which candidates of which party Latinos were voting for. That trend has completely reversed itself. Now there's a 34-point percentage gap in partisan affiliation for Latinos. I'm sure you can all figure out why. I certainly can. In traditional areas where Latinos have lived for a long time, the West and the Southwest, Latinos are growing into majorities, and we're seeing that now as we're coming up into redistricting. Latinos are growing into majorities in jurisdictions where before they were only in the minority, and this has a profound effect on how we do redistricting. These are also areas with long histories of exclusion of Mexican Americans and other Latinos from voting, as well as education, employment, housing, and public accommodations. So throughout the Southwest, where we had segregated schools, segregated pools, segregated bathrooms, in all of these places, Latinos are now growing into majorities, and that's presenting an important political challenge. And then there are areas of new arrival where Latinos are coming where they haven't been before and starting to comprise really substantial numbers, and numbers that we have to take a look at. Not necessarily majorities in jurisdictions, but something that's important. So the number that's been rolling around in my head, because I was so surprised when I saw it, is that there are now more Latinos in North Carolina than there are in Nevada. Think about it. That's like, wow. You think of Nevada as a southwestern state, it's got to have a lot of Latinos in it. North Carolina, you know, nobody thinks of that as a Latino kind of place. But now there are more Latinos in North Carolina than Nevada. Latino political potential is really fueled by two engines. The first and most important engine, and if you remember anything I say, please remember this: natural increase. Native-born Latino citizens turning 18. We have a young age structure in the Latino community. We also have higher fertility rates. I have 3 kids. I think only Dr. Gaddy may beat me on this panel. So we have, because we're young and because we have more children, our natural increase is very fast. And then the second, of course, is immigration and naturalization, but it's a much smaller component. I think that our work to create new opportunity districts will be focused on the Southwest, the West, and to some degree the Southeast. And then the last thing that I wanted to mention to you, since I only have a little bit of time left, is that there's a really strong pushback that's being carried out, and it's also very well designed, against the growing Latino electorate. So for example, states that are now screeching about this non-existent phenomenon of non-citizen voter registration. You're hearing people say, oh my God, non-citizens are registering to vote. They're polluting the purity of our election system, right? When nobody can actually find examples of non-citizens who fraudulently registered to vote. We took the deposition of every election administrator in Arizona when we were doing our litigation against the Arizona law that imposes the documentary proof of citizenship requirement. Not a single one knew of a non-citizen who had purposely registered to vote knowing he or she was ineligible. They had a very small handful of occasions where people thought because they were in the naturalization process and somebody convinced them, oh, it's okay to sign the card. And that was not a knowing or fraudulent registration. But we do have this sort of heated up rhetoric about non-citizens registering to vote. We've got to put, stops on that by requiring either naturalized citizens or others coming in newly into the electorate to show paperwork to show that they're citizens. This creates barriers to registration. This is also now a new thing that they're doing in Georgia, which was the subject of Georgia v. Holder. Let's run all the new voter registrants against the driver's license database and see who's a citizen and who's not, despite the fact that many newly naturalized citizens took out their driver's licenses when they were legal permanent resident immigrants. And so whatever data is in the driver's license database, when the person showed the green card as proof of authorized stay or proof of identity, it goes into the database as, oh, this person is a legal permanent resident. 2 or 3 years down the line, when the person naturalizes and registers to vote, this should be a smooth process. You naturalize, you're waving the little flag, you're taking the oath of citizenship. It's one of the proudest moments in people's lives. The first thing somebody wants to do is exercise their constitutional right to vote. Next thing you know, they get a letter saying DPS or the Department of Motor Vehicles says that you're not a United States citizen, come in and prove it. So these are all ways in which we're seeing a pushback. And then finally, of course, the attack on birthright citizenship. I need not say more, except that these things are always prefaced by talking about the growth of Latinos demographically. You will always hear discussions about the growth of Latinos and immigrants in the United States before somebody opens their mouth and says, take away birthright citizenship. Thank you.
Thank you, Nina. Now we have an opportunity to talk amongst ourselves and pretend they're not here. But as Anita also said, it is wonderful to see former colleagues and persons who are involved in the struggle to continue to enforce voting rights in the Voting Rights Act. I just want to ask each of the panelists questions based on their presentation. And the first question is for Kristen. How can we use the insights or admissions that Justice Kennedy had in the opinion regarding racially polarized voting and the persistence of racism in the electoral process to our advantage?
Well, I think it's really important to remember that, again, we can't make any blanket assumptions from the 2008 presidential election and the victory of Obama. It's, of course, a very proud moment, I think, in American democracy. But the reality is one in which racially polarized voting, ongoing examples of voting discrimination prevail in many communities throughout our country. And we've got to remember that redistricting happens at the local, city, county, state, and federal levels. And so we've got to really drill down to what's the situation in your community. And indeed, when we kind of do that micro-level analysis, we see that, despite the fact that Obama prevailed, there are many areas where whites continue to vote as a bloc to defeat minority voters, candidates of choice, where we're seeing discriminatory voting changes that continue to be blocked by the Department of Justice's enforcement of Section 5. So I think it's important to just take those blinders off and really drill down to what's happening at the micro level.
Thank you. Bob, you mentioned the New Black Panther Party as a distraction and taking resources from the Department of Justice, and those claims will certainly come up again as we begin the redistricting process, issues of politicalization. So how should DOJ respond to claims of politicalization that will certainly come up as we begin this redistricting process?
I think AAG Tom Perez has been very straightforward in terms of announcing what the division's policies are and how they plan to go about enforcing the law. I think to some of the critics that are out there, no matter what he says or no matter what the division does, they're going to continue to level these types of criticisms. I've been critical of the department myself in the past, and so I think criticism comes with the territory. But I think this latest round is really rather misplaced, and I think there's an unwillingness perhaps to take Tom Perez's word for what the department's policies are, and I believe that in this case that should be done. I think as I mentioned during the period of the Shaw versus Reno cases, there were a lot of those types of there was a whole different line of criticism leveled at the department and the section, and the staff there worked their way through it, and I think they will work their way through this. It's difficult, and I feel that this is unnecessary, an unnecessary diversion, but I think they'll get through it.
I think I've read that this is the first Democratic administration that will review submissions directly after census, since the Voting Rights Act. So I mean, how will that? So it's crucial that the Department of Justice is focused on its task. So I mean, how can we give them some ideas, insights, or just tell them to focus on the task at hand, which is major, particularly with Bartlett and NAMUDNO. So if any of you want to provide some comments as well. Anyone else?
Well,
I will say that the Department of Justice is not focused on its task right now to defend Section 5.
Okay.
I will say that in Georgia, where we were dealing with the issue that I just told you about involving the improper rejection of thousands of United States citizens for voter registration, where the Department of Justice objected to the procedure when it was submitted for administrative preclearance, and then on a request for reconsideration, I don't know what you say, renewed its objection, stood by its objection, I don't know what the technical term is.
Declined to withdraw.
Declined to withdraw its objection, which we heartily agreed with. When Georgia sued for preclearance in the DDC and people from Georgia intervened in opposition to preclearance of this very discriminatory measure, the Department of Justice completely flipped its position around because there was a constitutional claim in the lawsuit, secretly and wrongly administratively precleared that practice in a very shameful act that then deprived us of the opportunity in court to litigate that issue with the opportunity to have judges decide it. And so my position is that the Department of Justice has strayed dramatically and in a very, very bad way from its mission right now.
Okay. Keith, did you have something to say?
I can't say it with that degree of passion. But in a nutshell, we have no knowledge what actually happened inside DOJ, at least nothing that we can prove. But if the Department of Justice has become risk averse in the defense of Section 5, avoiding any confrontational preclearance in an effort to avoid a constitutional challenge, it effectively handcuffs the use of Section 5.
Explain.
Well, you may have a situation where you have a state that is seeking to bail out, or a jurisdiction seeking to bail out, and they craft a districting plan or a districting scheme which Department of Justice takes issue with, and maybe the degree of separation, the assessment of compliance with non-retrogression is a matter of degree rather than order of magnitude. They take it up to the D.C. District Court, get it to the Supreme Court, and the Supreme Court lands foursquare on the constitutional issue. And then suddenly there's no Section 5. Again, this is a worst case scenario, but it means the Department of Justice, if they are risk averse about this, will have to pick and choose carefully where they aggressively use Section 5. But again, having no evidence to speak to this, but if you want the hypothetical, that's what it looks like.
Do the panelists think that we can expect more cases, more submissions going to the D.C. District Court as opposed to more than we did in the last redistricting cycle and this in 2011? Do you think more jurisdictions will make their submissions to D.C. District Court as opposed to the Attorney General? That we'll see more litigation on that in that regard?
Well, I think we did see a bit of forum shopping during the last redistricting cycle. One example that comes to mind is Louisiana, which opted to take its discriminatory redistricting plan to the D.C. District Court, where they probably hoped to get a better outcome than they would have gotten before the Justice Department. But ultimately, they were unsuccessful and had to restore a majority-minority district that they had stripped away from the New Orleans area. I anticipate that we may see that kind of forum shopping happening again, but I think as Nina rightly points out, we don't know what to expect with respect to the Justice Department's enforcement of Section 5. The work of advocates and civil rights organizations remains very critical. We've got to ensure that we bring pressure to bear. We've got to ensure that we are all doing our part and working to kind of speak up where we see discrimination afoot in the redistricting process.
How can we empower grassroots organizations and citizens in this next redistricting cycle? What kinds of things should we be educating the public about?
I'll jump in there. I think it is really important that people have access to the technology to be able to evaluate plans and draw their own plans. That's sort of if you're going to have an effective voice at the table, you've got to be able to do that. But then they also need advice about what the legal standards are. And I think in addition, the social science research that will both say where racially polarized voting is strongest in their areas, as well as what other factors impacting the ability of minorities to participate in elections needs to be a part of the record, needs to be sort of available to them. So it's not as, I mean, part of it is going out and letting people know about the redistricting process. Part of it is advocating for transparency in redistricting, for public access and public hearings. But there's also capacity building that has to happen at the local level.
Can you talk a little, Anita, about Section 2 and its importance to this next round? And
well, I think if you look at the cases that have come through, there have been some important key Section 2 victories in certain areas, but for the most part, over the past 10 years, Section 2 has not been as strong a tool, in part because of the erosion of the racially polarized voting standard under Section 2. So while, and then the other problem is that you have to wait till you get a plan and then you can sue, and once you have a plan, people are getting elected, and it just changes entirely the dynamics. So it's important to be ready and able to file a suit when it's justified, and I think especially with regard to Latino voters, Section 2 is going to be a very strong tool in the next round. But I also think that there's ways in which it's not as strong as we need it to be right now.
Bob?
If I could just add to Anita's comments, the need for support at the grassroots level in terms of having skills with the GIS and software plan drawing is clearly important. I think one other aspect at the local level that's important is for communities to help define themselves. When you look at redistricting literature and discussions and deliberations, you see countless references to communities of interest. And that's an idea that means many things to many different people. But I think one of the things that a community, a minority community, or others can do is really help define themselves for the redistricting process, to put before the decision maker what it is that makes them a community that needs to be respected during the process, not to have district boundaries run down the middle of their community and place them into separate districts. That's one of the things that need to be always considered during redistricting. So that's just one additional aspect.
You know, the technology is the key, but we're almost too late in the cycle. Data collection's been underway for a while. Florida is developing FREDS 2010, the Florida Redistricting System, which will be available on the internet, freely accessible to the public, and anybody should be able to go up and draw districts. Michael McDonald over at Brookings has been working on a web-based application to be used around the country. And I know in several states,